She found a grieving man's empty house 41 days after his wife died. For 4 years, Diane Coulter ran Magnolia Creek like her personal kingdom, targeting the elderly, the immigrant families, the people she believed would never fight back. 11 families gone. Over $1 million quietly moved into her own pocket. She was right about all of them. Then Elliot Vance came home. And he'd been watching her for a very long time. Laurel Line. The morning inspection never changed. 6:15 sharp, Diane Coulter stepped out of her white Range Rover, MGLA1 on the vanity plate, carrying her iPad in its monogrammed leather case, her heels clicking a precise rhythm on the freshly sealed pavement of Magnolia Creek Estates. 47 homes. 212 residents. Every mailbox, every lawn edge, every roofline antenna, all of it under her authority as HOA president for the past 11 years. She walked the way people walk when they believe they own the ground beneath their feet. The Hendersons on Birchwood had left their recycling bin out 17 hours past the collection window. Diane photographed it, logged it, and generated a $75 fine before she'd finished her coffee. The Patels on Sycamore Lane had planted red begonias in their front border. The Magnolia Creek Residential Standards Manual, Section 4, Article C, permitted only white or cream flowering annuals in visible front beds. Another photograph. Another fine, $150, repeat offense. By 7:30 she had documented 9 violations and generated $680 in fines. She stopped at the corner of Laurel Line. Number 22 had been empty for 4 years. The family that owned it, she'd never bothered to learn their name, just called them the absentees in her reports, had let the lawn go twice the permitted height 2 summers running, and she had found an empty house with the same satisfaction she found an occupied one. Rules didn't care whether you were home. But today there was a truck in the driveway. Not a sleek truck. Not the kind of truck people in Magnolia Creek drove. It was a dark blue Ford F-250 with road dust still on the rear fender and a faded parking sticker from a federal building in Memphis. A man was unloading boxes. He was in his mid-60s. Black. Tall, with the unhurried posture of someone who had spent decades in rooms where patience was not a virtue but a weapon. He wore a plain gray shirt and work boots. No watch. No sunglasses. He carried a box of books and set it down on the porch with the same deliberate care you'd give a piece of evidence. Diane straightened her jacket and crossed the lawn. "Good morning," she said, tapping her iPad awake. "I'm Diane Coulter, president of the Magnolia Creek Homeowners Association. I'll need your signed resident acknowledgement form within 48 hours of occupancy. That's Section 1, Article A of our governing documents. I also need to inform you that this property has accumulated $6,200 in outstanding fines for maintenance violations during the vacancy period." The man set down a second box. He looked at her. Not quickly, not defensively, the way a doctor reads a chart before speaking. "Good morning," he said. "Elliot Vance." He did not extend a hand. "I'll need copies of the governing documents, the fine ledger with itemized descriptions, the minutes from every board meeting at which these fines were approved, and the original recorded declaration of covenants from the county recorder's office. Please send everything to this address." He handed her a business card. Small print. A federal seal in the corner. Diane read it. Honorable Elliot R. Vance. United States District Court Judge, 6th Circuit, retired. She looked up. He was already walking back to the truck. "I'll be expecting those documents by end of business Friday," he said pleasantly, and lifted another box. Diane drove home and called her attorney. "He's probably just trying to intimidate you," said Gerald Pratt, who had been the HOA's legal counsel for 8 years and had never lost a case against a resident, because no resident had ever had the resources to fight back seriously. He was a federal judge, Gerald. Retired federal judge. "Read the card I'm sending you." 30 seconds of silence on the line. "Diane," Gerald said. "Be careful with this one." Elliot Vance unpacked slowly and methodically. He was not a man who rushed. 26 years on the federal bench had trained that urgency out of him entirely. Urgency led to sloppy reasoning. Sloppy reasoning led to reversible error. He had spent his career watching attorneys destroy perfectly good cases by moving too fast. His wife, Margaret, had chosen this house. That was the fact he returned to every time he thought about Magnolia Creek. She had driven down from Memphis on a Saturday in April 2020, walked through the empty rooms, stood in the backyard looking at the old red maple in the corner, and said, "This is it. This is where we retire." She had been dead for 3 years. Pancreatic cancer. 8 months from diagnosis to the end. He had kept the house because it was the last thing she had chosen. He had kept it empty because every time he drove down from Memphis intending to move in, he found he couldn't cross the threshold without the grief turning physical. settling in his chest like something that needed more space than he had. And then, 41 days after Margaret died, while he was still in the kind of sorrow that makes a person forget what state they live in, the HOA had mailed a $200 fine for lawn height to an empty house. He had stared at that notice for a long time. Now, he had thought, pulling out of his Memphis driveway on a Tuesday morning, a manila folder of 11 violation notices on the passenger seat. It's time to go home. He opened the kitchen drawer and placed the folder inside. Then he put on coffee and went to meet his neighbors. The first was a woman named Rose Pham who lived at number 24, directly next door. She answered the door holding a dish towel and studied him with the careful assessment of someone who has learned not to extend trust before it has been earned. "You moved into the empty house," she said. "Elliot Vance. Just arrived today." She held his gaze a moment longer, measuring something, then opened the door wider. "Come in. I'll make tea." Rose Pham was 51 years old. She taught 3rd grade at Clement Elementary School 20 minutes away and had bought her house with 14 years of savings and a $40,000 inheritance from her mother. She had lived at number 24 for 3 years, and for 2 of those years she had been receiving violation notices from the HOA. The first was for wind chimes. Section 7, Article B, no noise producing decorative elements visible from common areas. The chimes had been her mother's. Rose took them down. The second was for her front door. She had repainted it a warm terracotta. The permitted colors, per Section 4, Article A, included 17 shades of white, 4 shades of gray, and colonial red, which turned out to be a very specific shade considerably darker than terracotta. Rose repainted the door. The $200 fine was retained. The third was for a small vegetable garden in her side yard, partially visible from the street. Section 6, Article D, no vegetable growing in areas visible from common street or sidewalk. The garden had fed her and her 9-year-old daughter, Lily. The fourth notice, and Rose's voice changed when she reached this one, becoming quieter and more careful, the way a person speaks about something that frightened them, was a letter alleging she had violated Section 9, Article A, creating a nuisance affecting neighborhood aesthetics and community cohesion. No specific violation was cited. The letter recommended she consider whether her current property might better suit her living needs and enclosed, helpfully, a list of properties for sale in adjacent zip codes. "Adjacent zip codes," Elliot said. "She does this," Rose said. "The ones who leave, Mr. and Mrs. Washington on Birchwood, the Garcia family, old Mr. Kim, they all got that letter first. Then their houses got sold to the same investment company. I looked it up after Mr. Kim left." She went to a kitchen drawer and came back with a folded paper. "This is the buyer." Elliot looked at it. Creekside Property Group LLC, registered in Delaware. He set the paper down. "Do you still have all 4 notices? Everything in writing?" "Every one. I kept them in a folder." She met his eyes steadily. "I'm a teacher, Mr. Vance. I know what documentation is for." For the first time since arriving at Magnolia Creek, Elliot allowed himself a small, private sense of optimism. The second neighbor was a man named Curtis Webb at number 19, who opened his door with the expression of someone who had been expecting a conversation he wasn't sure he deserved. Curtis was 53, an accountant, and had been a member of the HOA board of directors for 3 years. He was a decent man who had joined the board because he genuinely believed in community governance and had spent the subsequent 36 months slowly realizing he was being used as a notary stamp. "She calls me the night before meetings," he told Elliot, standing in his living room with his arms folded across his chest. "Tells me what's going to be voted on. The meeting happens, she runs it, I sign the minutes afterward. I thought that was just how small organizations worked." "It is not how they are supposed to work," Elliot said. "I know that now." Curtis's jaw tightened. 2 weeks ago she had me co-sign a service contract renewal with a landscaping company. $60,000 a year. I found out afterward that the company is owned by her brother-in-law. "Did you ask her about it?" "She said it was a competitive bid process and I was welcome to review the documentation." A pause. There was no documentation. Elliot looked at him evenly. "Curtis, I want to be direct with you. The position you're currently in has 2 possible outcomes. You can remain on that board and continue signing what you're told to sign, in which case what is coming will name you as a participant. Or you can decide, right now, that you are a witness." He let that sit in the room for a moment. A witness has considerably more options than a participant. Curtis was quiet for almost a full minute. Outside, a lawn mower started up somewhere on the street. "What do you need from me?" he finally said. Elliot spent his first 2 weeks at Magnolia Creek doing very little that appeared significant from the outside. He repaired the porch fence. He planted the back garden, tomatoes, basil, 2 varieties of pepper that Margaret had always grown. He introduced himself to neighbors without agenda, just conversation, and he listened with the full attention that had made him, over 26 years, a judge that attorneys on both sides of a case respected even when they feared his rulings. What he assembled, in small precise handwriting in the green notebook he carried in his breast pocket, was this. Diane Coulter had been HOA president since 2013. In that time, the HOA's annual operating budget had grown from $180,000 to $410,000. The growth was concentrated in 3 areas: landscaping, now contracted to Emerald Grounds LLC, owned by her brother-in-law Todd Coulter; administrative services, contracted to Coulter Property Management, a sole proprietorship registered to Diane's home address; and compliance consulting, contracted, again, to Coulter Property Management. Combined, these 3 arrangements paid Diane Coulter and her immediate family approximately $190,000 per year from HOA fees paid by people like Rose Fahm and Curtis Webb and elderly Mr. Salgado on Oak Run, who had received a foreclosure threat while recovering from a knee replacement. Elliot also found that the HOA's Declaration of Covenants, originally recorded at the county in 1987, had been amended 3 times under Diane's presidency. The amendments had expanded board authority, removed the right of residents to petition for independent audits, and significantly increased the fine schedule. Each amendment claimed ratification by the required 2/3 supermajority of homeowners. He submitted a public records request to the county for the original ratification documents. They did not exist. The amendments had never been properly recorded. They had never been legally ratified. They were, in the precise language Elliot had spent 26 years applying, a nullity, void from inception, unenforceable in any court that read them carefully. He closed his notebook, made coffee, and sat in the back garden under the red maple. Whenever you're ready, he thought. There's no hurry at all. Diane's first direct escalation came at the end of Elliot's 3rd week. She knocked on his door at 9 in the morning carrying a new violation notice. The notice cited Section 4, Article G, exterior surfaces must be finished in one of the approved colors listed in Appendix B as front porch boards, natural weathered wood, original to the 1992 construction, were not listed in Appendix B. These boards have never been painted, Elliot said. They are the original construction material. That doesn't exempt them from current standards, Mr. Vance. Previous residents were in violation as well. The HOA extended courtesy during the vacancy, but now that the property is occupied. Ms. Coulter. His voice was entirely without heat. I'd like you to identify for me, specifically, the board meeting at which this notice was approved and the vote count that authorized it. She tilted her head slightly, a small recalibration she performed when something was not going as expected. Board decisions on routine violations don't require individual meeting votes. The original Declaration of Covenants, Article 8, Section 3, requires a recorded board vote for any fine exceeding $200. This fine is $350. He held the notice out to her. I'll expect the meeting minutes within 5 business days. If the vote was not properly taken and recorded, the fine is unenforceable. He paused. I should also mention that I'm recording this conversation. He held up his phone briefly. Tennessee is a one-party consent state. Diane took the notice back. She left without responding. From his car she called Gerald Pratt. He cited the 1987 declaration. Gerald. The original, not our amended version. A silence. Where did he get a copy of the 1987 declaration? I don't know. That, Gerald said, is a serious problem. The matter of Rose Fahm's employment was, in retrospect, the moment Diane Coulter made the error that made everything else that followed inevitable. On a Thursday morning in Elliot's 5th week, Rose received a call from her school principal, a man named Dale Hartfield, who said he had received an anonymous letter expressing community concern about a staff member's history of financial disputes and HOA violations that may reflect on professional responsibility and suitability for a role in children's education. The letter had been sent on HOA letterhead. Rose called Elliot, and he could hear in her voice, not quite broken, but leaning hard against something, the specific quality of a person who has absorbed one blow too many and is deciding, in real time, whether to go down or stay standing. Come over, he said. When she arrived, he already had his notebook open. Tell me everything, Principal Hartfield said. Exact words as best you can remember. She told him. When she finished, he looked up from his notes. That letter is defamation. HOA authority does not extend to employment communications, and every allegation about your financial responsibility is either factually false or based on fines that are legally unenforceable. Using the HOA's letterhead to transmit false statements to your employer constitutes tortious interference and potentially extortion. He said this without drama, because accuracy was a form of respect. More importantly, it is a tactical mistake on her part. She escalated because she is frightened. Frightened people stop being careful. He turned the laptop toward her. I need to show you something. He had built a spreadsheet covering 3 years of HOA financial records, violation histories, fine assessments, service contracts, and property transfer data. Highlighted in yellow were the names of 11 former Magnolia Creek residents. Next to each name, their violation history, the nature of Diane's escalation against them, the date they sold, the sale price, and the purchasing entity. Every buyer, through various shell arrangements, traced to one entity, Creekside Property Group LLC. Rose's address appeared in the active column. 3 months of escalating violations. The Section 9 cohesion letter in red. She was going to make me leave, Rose said quietly. Yes. She has been doing this systematically for at least 6 years. He paused, because what he needed to say next required care. I also need to show you a pattern in the data that goes beyond the financial fraud. He opened a second document. A simple table. Names, demographics, violation escalation dates, Section 9 letter dates. Every recipient of the Section 9 letter has been a person of color or an immigrant family, he said, and let the room hold that for a moment. This is not an allegation of conscious, deliberate prejudice in the legal sense, though it may be that too. But the Fair Housing Act of 1968 does not require proof of conscious intent. It requires demonstrated disparate impact and a documented pattern of discriminatory effect. Both are present here. 11 families. 11 Section 9 letters. Not one white homeowner among them. The room was very quiet. I've lived here 3 years, Rose said finally. I thought I was just unlucky. You were not unlucky. You were targeted. And there is an enormous legal and human difference between those two things. She looked at the screen for a long time without speaking. Then, what do we do? We finish building the record, Elliot said. And then we show it to everyone who needs to see it. Curtis delivered the documents that made a criminal referral possible. 3 years of service contracts. Bank transfer records showing payments from HOA accounts to Coulter Property Management and Emerald Grounds LLC. Emails from Diane directing Curtis to sign contracts without board authorization. And one specific email, which Curtis had kept because something in him had understood, even then, that he might someday need it, in which Diane wrote plainly, just sign the Emerald renewal. Don't bring it to the meeting, it'll just confuse things. Don't bring it to the meeting. The violation of fiduciary duty was not implied or reconstructed from circumstantial evidence. It was explicit, documented, and written in her own words. Elliot's attorney, Patricia Lang, a real estate and civil rights attorney who had been watching Magnolia Creek from a professional distance for 2 years, waiting for a case that could survive contact with the law, spent 3 evenings with the full file. When she called Elliot at 10 o'clock on a Wednesday night, her voice carried the particular restraint of a person working hard to remain professional about something that was making it difficult. We have breach of fiduciary duty, self-dealing, tortious interference, defamation, and Fair Housing Act violations. The targeting pattern is a textbook Section 3604 case. We also have potential wire fraud on the federal contract certifications if the bids were falsified, which I believe they were. She paused. Elliot. This is not a civil dispute. This is a criminal referral. I know. I want to contact HUD and the FBI Fair Housing Unit. Schedule it, he said. But I want to go to the residents first. Before anything is filed publicly. They deserve to hear it in person, from us, before it becomes news they find out about from somewhere else. Diane Coulter could feel the structure of her world developing cracks long before she could see exactly where they were. Elliot Vance had stopped responding to violation notices. Not ignored them, stopped responding, which was a different thing entirely. Ignored notices gave her leverage, escalation, late fees, the slow accumulation of financial pressure that had worked on every other resident for 11 years. Silence gave her nothing to push against. She had built a system that ran on compliance and the credible threat of consequences, and he simply declined to participate in it. She had tried a direct approach, invited him for coffee, framed as a community orientation session. He had accepted, arrived on time, listened without interrupting, and when she suggested that his combative posture was creating tension in the community, he had asked, in the same pleasant voice he used for everything, whether she could provide the recorded ratification documents from the 2019 amendment process. Those are in the permanent records, she said. I made a public records request to the county for the recorded documents. They have no record of the ratification vote. His expression remained mild. I'm sure it's simply a filing oversight. I'm sure those records exist somewhere. She had gone home and called Gerald. Gerald had said things she did not choose to repeat to herself afterward. Her son, Tyler, called from Seattle that evening. The conversation lasted 4 minutes. He had a dinner reservation. She sat alone in her living room for a long time after, looking out at Magnolia Creek through the front window, the perfect lawns, the uniform mailboxes, the precise, ordered beauty she had spent 11 years building and maintaining against entropy and carelessness and everyone who didn't understand what a real community required. She thought, I made something real here. I made it better than it would have been without me. She believed this. That was the part people would never fully understand about Diane Coulter. She genuinely believed it. The financial arrangements, the targeted letters, the contracts with her brother-in-law, all of it existed inside a larger story she told herself about a neighborhood that needed her, that only functioned because someone cared enough to enforce the standards that kept it from sliding into disorder. She poured a second glass of wine and stayed busy enough not to hear what was underneath that story. The community meeting was called by petition. Under the original 1987 declaration, not the amended version, the original recorded declaration which, as it turned out, had governed the HOA in its entirety all along, 15% of homeowners could compel a special meeting of all residents. Elliot went door to door on evenings and weekends, not campaigning, just talking. Telling the story plainly. Showing the documents to anyone who wanted to see them. By the end of the third week he had 31 signatures. 22%. The meeting was set for a Tuesday evening in the Magnolia Creek clubhouse. On the Sunday before, Diane appeared at his door. She wore a pale blue blazer and carried her iPad loosely at her side, which, for Diane Coulter, was the closest thing to a white flag her posture was capable of expressing. She made a formal offer, waive the entire $6,200 in accumulated fines, rescind the violation history against Rose Fahm, and move forward constructively as a community. Elliot invited her in. Made coffee. Listened to the complete offer without a word. Then he said, I appreciate you coming, Diane. I'll be straightforward with you. We are past the point where waiving my fines resolves this situation. What has been happening here affects 47 households, involves criminal conduct rather than governance disagreements, and has caused real harm to people who are no longer in this neighborhood because they were driven out of it. The meeting Tuesday is not about my fines. Diane set her coffee down carefully. You're going to destroy something I spent 11 years building, she said. The professional surface was still there, but considerably thinner. No, Elliot said. His voice was not unkind. What I am going to do is an accurate accounting of what was actually built here. That is a different thing. She left without finishing her coffee. He stood at the window and watched the white Range Rover back out of his driveway and thought about Margaret, about the woman who had stood under that red maple and said this is where we retire, and about how, 41 days after she died, a stranger had mailed a fine to an empty house. He turned from the window and went back to preparing his presentation. Tuesday evening. 163 residents came. The clubhouse held 90 comfortably. People stood along the walls, sat on folding chairs in the doorway, crowded into the entry hall. Several told Elliot afterward they had never attended a community meeting before. He believed them. Attendance at Diane Coulter's regular meetings had averaged 11 people, and those 11 had been largely self-selecting, the compliant, the connected, and the carefully managed. Diane sat at the front table. Dressed precisely, hair perfect, iPad open in front of her. From 20 feet away Elliot could read the difference between the confidence of a person who holds power and the performance of a person who is trying to look like they still do. Patricia Lang handled the legal framework first, establishing clearly and without unnecessary complexity that the 1987 Declaration was the operative governing document, that the amendment process had never been properly followed, and that 11 years of rule additions were legally unenforceable. She was methodical and took 20 minutes. When she finished, the room was already different from how it had started. Curtis Webb read a prepared statement. His voice found its steadiness after the first few sentences and held it. He described the contracts he had signed, what he had not understood at the time he signed them, and what he had come to understand since. He took responsibility for his passivity with the directness of a man who had decided that protecting himself was no longer worth what it cost other people. Then Elliot stood up. He had presented in federal courtrooms for 26 years, before defense teams and prosecution teams that included some of the finest legal minds in the country, on cases involving constitutional precedent and national consequence. He brought exactly the same seriousness to a community meeting in a suburban clubhouse, because the people in the room deserved it. He walked through the financial data slowly, in plain language, with charts that anyone could read without legal training. The service contract payments to family-owned companies, $190,000 per year, 11 years running. The amendment ratification records, or rather their documented absence. The violation fine history laid out as a pattern rather than a series of individual incidents. And then the demographic data. He presented this carefully, because he understood its weight. Every recipient of the Section 9 Community Cohesion Letter, the letter that recommends residents consider selling their homes, has been a person of color or an immigrant family, he said, and allowed the room a moment with that before continuing. The Fair Housing Act of 1968 does not require proof of deliberate intent. It requires a demonstrated pattern of discriminatory effect. That pattern is documented here. 11 families. 11 letters. Not one exception. He paused. Those 11 families cannot be in this room tonight. They have already left. I believe we have an obligation to say clearly what happened to them, even in their absence, especially in their absence. Mr. Salgado, 74 years old, who had received a foreclosure notice while lying in a hospital bed recovering from surgery, raised his hand and said, in a voice that held the specific quietness of someone who has spent a long time absorbing things alone, I thought it was just me being difficult. I thought maybe I didn't understand the rules. You understood the rules, Elliot said. The rules were being misapplied against you. Rose Fahm stood up without raising her hand and told her story directly, looking at the people in the room rather than at notes. She had been speaking for perhaps 30 seconds when the woman seated next to her, a neighbor she had greeted across driveways for 3 years without ever learning her name, a woman named Sandra who had received her own Section 9 letter 8 months ago and had been quietly researching real estate listings ever since, believing herself to be the problem, began to cry. Not quietly. 2 more residents stood up after Rose. Then a third. Diane Coulter said nothing during any of this. She sat at the front table and held very still, meeting the eyes of anyone who looked at her, because looking away would be an admission, and she had not made an admission in 11 years. She was still holding that posture when Patricia Lang said, I also need to inform the room that a referral has been submitted to the HUD Office of Fair Housing and the FBI Economic Crimes Unit. An investigation is currently underway. Individual board members may receive contact from investigators in the coming weeks. The vote was not close. The motion to remove Diane Coulter from the presidency and suspend all board authority pending an independent governance review passed 147 to 16. Diane placed her iPad in its case with the same precision she brought to everything, buttoned her jacket, stood, and walked out of the room. No one blocked her way. No one followed her. The door swung shut behind her, and in the silence that followed, Elliot sat down. Aftermath is slower and less satisfying than the stories about it suggest. The FBI investigation took 7 months and produced federal charges against Diane Coulter and 2 principals of Creekside Property Group LLC, wire fraud, conspiracy to commit Fair Housing Act violations, and breach of fiduciary duty in a federally connected financial arrangement. Gerald Pratt negotiated a plea that avoided trial. The result was substantial fines, 5 years of supervised release, and a permanent bar from serving in any HOA governance or property management capacity in the state of Tennessee. The HOA's independent audit found that over 11 years, approximately $1.1 million in resident fees had been paid to Coulter-affiliated entities without proper board authorization. A civil suit was filed. Settlement negotiations ran for another 8 months. The 11 families who had been pressured out of Magnolia Creek could not be made whole. They had sold their homes, dispersed, built other lives in other places. The transaction records existed, the pattern was documented, the harm was legally established, and still, reversing what had been done to those 11 families was not fully possible. This was the part of the resolution that Elliot found hardest to sit with. Not the legal complexity of it, which he understood well. The human fact of it, that justice for the people still present is achievable, and justice for the people already gone has its limits, and those are not the same thing. He said this plainly at a follow-up community meeting 3 months later. I want to be honest about what was accomplished and what wasn't, he told the room. We stopped an ongoing pattern of discrimination and financial fraud. That matters significantly. We did not restore what was taken from the families who came before us, and that also needs to be acknowledged without softening. He paused. What we do with that acknowledgement is a decision that belongs to this community. The newly elected board, properly constituted, with Curtis Webb as treasurer and a physician named Dr. Amara Osei as president, voted to establish the Magnolia Creek Housing Equity Fund, $75,000 from the HOA's reserve accounts, dedicated to legal assistance for low-income homeowners facing housing discrimination, with priority given to former Magnolia Creek residents who wished to pursue civil claims. It was not enough to repair everything. It was something real, built from the wreckage of something that should never have been built in the first place. Rose replanted her vegetable garden in April. Lily, 10 years old now, helped set the tomato cages and asked, with the focus gravity children bring to questions that matter to them, whether they were allowed to have a garden this time. Yes, Rose said. Because the rules changed? Rose pressed a cage into the soft earth and thought about how to answer that accurately. Because someone took the time to understand the rules completely, all of them, including the ones that had been hidden or ignored, and showed everyone which ones were legitimate and which ones weren't. She looked at her daughter. The rules themselves were always supposed to protect people. They'd just been taken over by someone who used them to do the opposite. Lily turned this over. Mr. Vance? Mr. Vance. He gave me a tomato plant last week, Lily said. I know. Rose smiled and moved to the next cage. That's one of the best things about him. Elliot found Margaret's note 3 weeks after the community meeting, folded at the back of a kitchen drawer where he had placed it without remembering, on the day he moved in. It was in her careful cursive, the handwriting she reserved for things that mattered, written on the back of the old real estate listing for 22 Laurel Line. This is where we need to be. The yard is big enough for the garden, and there's room for a proper library in the back room. I know you think I'm being impatient, but I'm not. I just know when something is right. Come home. He sat at the kitchen table for a long time holding the paper. The red maple was visible through the window, its spring leaves that particular yellow-green that means something is exactly as alive as it ought to be. He thought about what the past months had taught him, not new lessons, exactly, but old ones made sharper by proximity. That systems of authority, however small, follow the same patterns regardless of scale. They expand toward the edges of whatever accountability they face, and they stop expanding precisely where someone draws a clear, documented, defensible line. That the documents enabling oppression and the documents dismantling it are often the same documents. The difference is whether anyone reads them carefully enough to know what they actually say. That Rose Fahm, a third-grade teacher who kept every notice in a folder because she knew what documentation was for, had understood something essential that 11 families before her had not had the resources or support to act on. That Curtis Webb had made a passive choice for 3 years, and then an active one, and that the active one had cost him something and mattered more. That courage takes different forms: the courage to speak, the courage to document, the courage to stay standing when the pressure is designed specifically to make you believe that leaving is easier and less shameful than fighting. And that justice, when it arrives incomplete. That learning to live with that incompleteness without letting it become an excuse for inaction, that is perhaps the hardest discipline of all. He folded Margaret's note and kept it in the breast pocket of his jacket, next to the green notebook. Then he went out to water the garden, in the yard she had chosen, on the street she had wanted, in the neighborhood that was, finally and imperfectly and irreversibly, becoming what a community is supposed to be. Know your rights. Read what you sign. Keep every document. Understand that the same rules used against you can, if you learn them precisely enough, be used to protect you. And remember that the courage to say this is wrong and the patience to prove it are both necessary, and that neither, alone, is sufficient.